All right, everyone, thanks for joining us today in the National Press Theatre. My name is Amanda Connolly from Global. I'll be the moderator for today. Joining me, we have David Lametti, the Minister of Justice and Attorney General of Canada, Hadju, the Minister of Health, and Carla Qualtrough, who is the Minister of Employment, Workforce Development, and Disability Inclusion. I believe the ministers have opening statements, so we'll let them take that away and then get to questions. Go ahead.
Thank you very much. Good afternoon, and thank you for being here. Bon après-midi. I would like to begin by acknowledging that we are gathered on the traditional unceded territory of the Algonquin peoples. C'est important pour moi d'être présent aujourd'hui en présence de mes collègues, l'honorable Patty Hadju, la ministre de la Santé, et l'honorable Carla Qualtrough, ministre de l'Emploi, du Développement de la main-d'œuvre et de l'inclusion des personnes handicapées. Today we introduce proposed amendments to the Criminal Code's provisions on medical assistance in dying. The proposed legislation directly responds to the decision of the Quebec Superior Court in Truchon from last September. In this decision, the court found the existing requirement in the law that the death must be reasonably foreseeable in order to access MAID to be unconstitutional. The court gave the federal government 6 months to respond. The proposed changes also help address other issues that received considerable rencontrer les obligations de la Cour. La semaine dernière, en tant que procureur général du Canada, j'ai déposé une demande de prolongation de 4 mois à la Cour supérieure du Québec. Sans cette prorogation, le critère de prévisibilité raisonnable de la mort naturelle de la loi fédérale ne s'appliquera qu'au Québec, ne s'appliquera plus au Québec à compter de 12 mars, mais restera en vigueur ailleurs au pays. Aujourd'hui, nous avons déposé les amendements nécessaires pour répondre à la décision. Ces changements nous demandent un travail parlementaire important et nous devons prendre le temps de le faire. Une décision aussi importante chamboule nos valeurs et vient directement toucher nos sentiments les plus profonds. Les gens qui décident d'utiliser l'aide médicale à mourir vivent des souffrances inimaginables. Nous devons penser à l'impact sur la personne elle-même, mais également sur ses proches. La proposition que nous faisons aujourd'hui est importante. Nous devons être à l'écoute des besoins des citoyens. Today we have tabled new legislation that modifies the federal framework on medical assistance in dying. First and foremost, we have widened the eligibility to access medical assistance in dying. This responds directly to the Quebec Court's ruling. As a result of the change, we have created 2 tracks within the framework, one for patients whose natural deaths are reasonably foreseeable, and a second for those whose natural death is not. Under both tracks, patients must be faced with intolerable suffering and be in an advanced state of irreversible decline as the result of an incurable illness. Aujourd'hui, nous avons déposé un projet de loi qui modifie le cadre fédéral sur l'aide médicale à mourir. D'abord et avant tout, l'exigence selon laquelle la mort naturelle d'une personne doit être raisonnablement prévisible pour avoir accès à l'aide médicale à mourir n'est plus nécessaire. Ainsi, nous répondons directement à la décision de la Cour supérieure selon laquelle cette exigence n'était pas conforme à la Constitution. Nous proposons de créer 2 avenues, l'une pour des patients dont la mort est raisonnablement prévisible et l'autre pour ceux qui ne sont pas en fin de vie. Dans les 2 cas, les souffrances doivent être intolérables, le patient doit être atteint de malade incurable et son état de santé doit avoir atteint un stade irréversible. We have also said that we would listen to the stories on the ground and act where there is a clear consensus among the Canadian public. We know that there are patients who have met all the criteria to receive MAID, but who are not quite ready to go ahead with the procedure. Many are worried that they will lose access to MAID because they risk losing their capacity to give their final consent. Some have chosen to end their lives prematurely, sacrificing their chance to spend more time with their families, because this was the only way to guarantee that they could still have access to MAID. This was the story of Audrey Parker and others. No one should be faced with such an impossible choice. That's why we are introducing an amendment that will allow patients who are dying to choose to receive MAID even if they have lost their capacity to finally consent at the time of the procedure. To balance the proposed changes that we have made to the framework, we are also proposing new safeguards. I will let my colleague, Minister Hadju, speak more fully to these measures. Nous faisons aujourd'hui un pas important. C'est une étape supplémentaire dans notre processus de réflexion commune. La réflexion n'est pas terminée. Nous allons continuer à étudier les différentes options qui vont émerger dans le futur. La révision parlementaire de la loi, qui devrait avoir lieu plus tard cette année, permettra de continuer à travailler sur ce sujet si important et sensible. Nous adressons aujourd'hui un enjeu qui touche directement les valeurs personnelles de chacun d'entre nous. En tant qu'élus, nous avons une responsabilité importante de s'assurer que nous accordons la liberté de choix aux Canadiens et Canadiennes, tout en protégeant ceux qui sont plus vulnérables. Je crois profondément que c'est ce que nous présentons aujourd'hui. Aucune décision que nous prenons ne devrait stigmatiser les gens qui ont fait un choix différent. I will now turn to my colleagues, Minister Hadju and Minister Qualtrough, to say a few words. Thank you. Merci.
Well, thank you very much, Minister Lametti, and hello to everyone. Over the past few months, we've spent quite a bit of time listening to Canadians and asking what they thought about medical assistance in dying. And as Minister Lametti said, the feedback was extensive. I thank all of those people who participated and shared their views and often very deep personal stories. You've helped us shape the changes that we are proposing today. I also thank the opposition parties who have participated in the consultations. During these consultations, we heard strong support for a bill where some safeguards would be eased for persons who are dying. And we also heard strong support for legislation where additional safeguards would be put into place for people who are not dying, but who meet all the other requirements for medically assisted death. We believe the changes that we are proposing today will help address situations where the suffering of people already deemed eligible for MAID has been prolonged unnecessarily. At the same time, we think it is important, even while improving access, to ensure vulnerable individuals are protected. And that's why we're taking a two-tracked approach to medical assistance in dying. The first, where natural death is reasonably foreseeable, and the second, where it is not. As Minister Lametti said, reasonable foreseeability of natural death will no longer be a requirement for determining whether a person can access medical assistance in dying. However, it will still guide practitioners in determining which safeguards to apply. It is a very familiar concept for them after 4 years of providing the service. For those whose death is reasonably foreseeable, we would ease some of the pre-existing safeguards that we know have not served their purpose of protection. Under the current system, there is a requirement for a 10-day reflection period. We have heard that this safeguard does not provide additional certainty or protection. So we are proposing to eliminate this reflection period. For those who are at the end of life, the decision to request medical assistance in dying is well considered, and this additional period can prolong suffering unnecessarily. The current system also requires that 2 independent witnesses confirm that the person who has signed a request for MAID is who they claim to be and that no fraud has occurred, such as someone forging a signature. During our consultations, we heard that this requirement was a barrier for many people at the end of their life. Some might not know anyone outside of their family or their care providers. We've heard that this requirement definitely blocks access. As such, we propose requiring only one witness and allowing this witness to be a care provider. Those involved in assessing or providing MAID would continue to not be eligible as a witness. Now, for those whose death is not reasonably foreseeable, we would create a new set of safeguards. For example, there would be a minimum period of 90 days for assessing the MAID request. This period will allow for exploration, discussion, and consideration of options by the person seeking MAID with their practitioner. The legislation also requires that the person requesting MAID be provided with information on available counseling, mental health supports, disability supports, and palliative care to provide that informed consent. Now, on the waiver of final consent. Under the current legislation, those who lose capacity also lose their eligibility for medical assistance in dying because they must be capable of providing final consent immediately before the procedure. Practically speaking, this means that some individuals deemed eligible for MAID have chosen to end their lives earlier than they've wanted out of fear of losing the opportunity to receive the service. Others have refused to receive medication that relieves pain out of fear of losing their capacity. This is unreasonable and unjust. And that is why our government is proposing to include a waiver of final consent for people whose death is reasonably foreseeable and who have been assessed and approved to receive MAID. This means that individuals at the end of their life who risk losing their decision-making capacity before their chosen date, like Audrey Parker, would have an avenue to receive MAID without worrying about the possible loss of capacity. Support for this amendment is strong among Canadians and health practitioners. Dealing with other questions of advance requests is complex and raises important discussions that Canadians must have. The Council of Canadian Academies expert panel report on advance requests concluded that dealing with advance requests made by people who are at the early stages of an illness or who have not yet been diagnosed with any illness at all is very challenging. For that reason, these scenarios will be considered during the parliamentary review process slated to begin later this year. We've heard from Canadians, experts, healthcare providers, and stakeholders. And Canada has learned a lot from our experience with medical assistance in dying over the last 4 years. As society changes, so too must our laws to give Canadians the dignity they deserve at the end of their lives. Thank you.
Thank you. Hello, bonjour tout le monde. I'm honored to be here alongside my colleagues, Ministers Lametti and Minister Hadju. Je tiens à remercier les Canadiens de nous avoir fait part de leur point de vue au cours des derniers mois. Il est évident que la question de l'aide médicale à mourir est très personnelle et sensible, et l'opinion des Canadiens continue d'évaluer à cet égard. From my perspective, as Minister responsible for disability inclusion, I'm working with my colleagues to ensure that the voices of persons with disability are heard. We also want to ensure that we don't do anything that in any way devalues the lives of or further stigmatizes persons with disabilities. Disability rights advocates have long fought for personal autonomy. Being able to make decisions about one's own life is fundamental. Les défenseurs des droits des personnes en situation de handicap luttent également pour l'égalité, car il n'y a pas une vie qui ait plus de valeur qu'une autre. Il existe de nombreux exemples dans notre histoire où l'autonomie individuelle et l'égalité de nos citoyens en situation de handicap ont été menacés, rejetés, ou ignoré. As we table these amendments to the federal MAID law, I want to be clear that we have carefully considered the input we received during our consultations. We have worked together to craft provisions that will balance making medical assistance in dying available without undue obstacles to those who choose it, with safeguards to ensure that this decision is truly informed and voluntary. For a truly progressive MAID law is one that recognizes, without compromise, the equality and autonomy rights of everyone. Mes collègues et moi-même poursuivrons notre conversation qui s'élargira au cours de notre prochain examen parlementaire. En tant que pays, nous devons trouver une façon de progresser qui continue de reconnaître l'autonomie individuelle et de protéger les personnes vulnérables tout en tenant compte des objections de conscience. At the same time, we need to ensure that we do not further stigmatize or marginalize people who are elderly, ill, or who have some form of disability. I look forward to the next steps and to continuing to hear from Canadians on this important issue. Thank you. Merci.
All right, thank you very much, ministers. We've got a few questions to get through here, and the mics still aren't quite working, so I'm going to say the person who will be doing the question and then the person who will be doing the next question at the same time. Our first question will go to Hélène Buzetti from Le Devoir, and our second question to Catherine Collin from CBC.
Oui, bonjour, Monsieur Lametti. Si je me souviens bien, lorsque la première fois cette loi-là avait été adoptée, vous aviez voté contre en vote final parce que vous n'étiez pas à l'aise, parce qu'elle était trop restrictive. Aujourd'hui, est-ce que vous êtes davantage à l'aise avec cette loi?
Oui, je crois que d'abord, on est dans un processus d'évolution et je crois qu'on a transformé d'une façon incrémentaire la loi selon vraiment les valeurs de nos concitoyennes qui sont en train de changer, qui sont en train d'accepter l'aide médicale à mourir et qui, maintenant, ça fait partie de nos attentes. Et donc, on a trouvé, je crois, comment procéder avec la prochaine étape.
Et vous avez décidé d'écarter la santé mentale à Québec, où on avait pendant un temps songé à le permettre. Il y avait eu un tollé, les spécialistes se disaient pas prêts et on a reculé. Dans quelle mesure l'expérience du Québec vous a inspiré?
Évidemment, ça faisait partie de nos réflexions, mais il y a aussi le fait que les experts nous ont dit la même chose. Il y avait d'abord, c'est une question complexe et on est en train, en tant que société, de mieux comprendre les maladies mentales. Mais ceci dit, les experts, les médecins, les infirmières nous ont dit qu'il n'y avait pas un consensus là-dessus, que c'était complexe. Et donc, on a entendu à travers le Canada ce que nos collègues, nos homologues au Québec ont entendu au Québec. Et donc, on va travailler, on va laisser les maladies mentales comme sujet pour étudier lors de l'étude parlementaire. On a le rapport du Conseil des académies canadiennes. Et le Québec va consulter aussi. Donc, nous sommes tous, je crois, de la même avis qu'il faut mieux comprendre et mieux évaluer la situation.
Hello.
Catherine Collin from CBC.
I wanted to ask, it's perhaps for Minister Hadju, but frankly for whomever wants to respond. I'm just thinking about trying to make it clear to Canadians where you're drawing the line in terms of people who no longer have the capacity to decide. So I know that there's the instances where people's death is already reasonably foreseeable, but at the same time, somebody who does have dementia could enter into a discussion with their doctor about medical aid in dying. Like, where is the line, and is there a conversation that will continue to evolve if this law passes?
So one of the things we heard very clearly from the practitioners that provided feedback at the roundtables and through a variety of different means was that they had become very adept at determining when someone was reasonably foreseeable in terms of an imminent death. And we're able to have those conversations with individuals. I mean, we have a great deal of respect for the profession and especially the practitioners who've been providing this service over the last 4 years. And the law is constructed in a way that actually gives some autonomy to physicians so that they can determine if someone's death is imminent or if someone's death is not. And they understand the framework as we have it written now with reasonable, foreseeable natural death. There's been a lot of work to determine what that means by the medical establishment, especially amongst those who are practicing. And so this two-track approach actually gives them some flexibility in determining who might be reasonably foreseeable to have an imminent death and who might not be. And I think there are good examples of conditions, for example, where you might not be dying in the next, year or even 2 years, and yet you have, irremediable suffering, or that you will not be getting better. And this allows for those patients that would not, in any way be facing an imminent death to also have an option with their physician if that was a choice that they made.
I think a lot of Canadians who are not nearly as immersed in the file as yourselves, obviously, when they think of medical assistance in dying, they often think of advanced directives. They think of a situation where they might have Alzheimer's, for instance, and not want to continue to live like that. Can you talk to me about why perhaps you chose not to go that far with this new piece of legislation?
I think, well, first of all, I think it is, obviously we heard that as well from Canadians, and oftentimes as a member of parliament I meet with especially senior Canadians who are very worried about what their life might look like if they were to be diagnosed with a condition like Alzheimer's. I should be clear that it isn't a condition that eliminates your ability. It is really a discussion between the practitioner, but the advanced nature of those requests are where actually many physicians have discomfort, and partly because they have seen patients who have been diagnosed with let's say Alzheimer's. It's a good example. And as the person gets closer to significant cognitive decline, doesn't necessarily express the same desire that they did when they were first diagnosed, that they wish to die. And so what practitioners have said is that this deserves a very careful consideration in terms of advance requests when a person anticipates what they might feel like with a condition versus what they may actually feel like. And so we believe this is deserving of a deeper examination through the parliamentary review, where we can actually get to those questions that are quite profound and quite difficult to answer, even for practitioners who have been doing this service for the past 4 years. So thank you.
Okay, Philippe Vincent Foisy from Radio-Canada, and then Rachel Haynes from CTV.
Oui, bonjour, M. Lametti. Deux petites questions. Pourquoi vous avez choisi d'avoir deux tracts, comme vous avez dit, un pour ceux qui ont la mort raisonnablement prévisible et un pour ceux qui ne l'ont pas? Et allez-vous donner plus d'argent aux provinces pour qu'il y ait justement les services dont vous mentionnez sur ceux qui n'ont pas la mort raisonnablement prévisible?
D'abord, pour la question des deux voies, on a, en 4 ans, on a accumulé des expériences et je crois que les médecins, les infirmières étaient confortables avec les standards dans l'Ancien Régime. Et donc, vu que la grande majorité des cas vont encore se situer dans la mort, dans la fin de vie, cancer, etc. La plupart des cas vont rester là. Donc, on a élargi un peu le cercle, si vous voulez, en ajoutant d'autres critères, mais c'est plus pratique d'avoir 2 voies. La deuxième voie va être moins commune. Pour l'argent, évidemment, on est toujours... l'administration, la santé, c'est la compétence des provinces. On est, en tant que gouvernement fédéral, nous sommes toujours en négociation avec les provinces. On a des transferts, mais on va laisser la question au ministre des Finances.
Sur ce qui s'en vient, est-ce que vous pensez que le projet de loi peut vraiment être adopté le 11 juillet si demain vous obtenez votre prolongation? Puis qu'attendez-vous des consultations en 2020?
Bien, on a prévu dans l'étude parlementaire 3 sujets, donc les mineurs, les demandes anticipées et les maladies mentales. Il y a peut-être d'autres, et aussi les soins palliatifs. Il ne faut pas oublier le fait que les soins palliatifs ont été identifiés il y a 4 ans. Évidemment, on va continuer avec ces sujets. On va regarder s'il y a d'autres questions abordées. On a déjà les études qui ont été produites par le Conseil des académies canadiennes. On a le rapport qui a été sur des demandes anticipées qui a été produit au Québec avant, évidemment, la décision dans Touchon. Mais il y aura d'autres études aussi, des commentaires académiques, etc. Donc, on va regarder le tout et on va consulter comme il le faut. Ça, c'est une autre étape. Donc, ici, on veut évidemment avoir la loi qui passe la sanction royale aussitôt que possible. Les autres questions sont plus complexes et on va voir.
Okay, Rachel Haynes from CTV, and then we're going to go to Lena Dibb from La Presse Canadienne.
My first question is for Minister Qualtrough about the specific measures put in the legislation in response to disability rights advocates who have worried in the past about the impact that the medical assistance of dying could have on people with disabilities. Is there a concern that allowing this waiver to consent when you lose capacity to consent, and if there's the fact that you have less witnesses now, could that put these vulnerable people at a greater risk?
Thank you for your question. It's really important to all of us as we went through this process to ensure that the safeguards resulted in a fully informed and supported decision making on behalf of the individual, while in no way compromising their individual autonomy rights. And so that was the balance we were trying to achieve. And what we did hear from disability rights organizations was that they felt that their rights were perhaps threatened with an expanded MAID regime. I'm very comfortable, and if you read the preamble of this C7, is it? We talk about our obligations under the United Nations Convention on the Rights of People with Disability. We talk about our charter rights, and I'm comforted by the fact that the second track, i.e. if you are not near the end of your life, there are actually bolstered safeguards. People have to be informed of options available to them, disability supports, palliative care, counseling services. That's what disability rights advocates were calling for, to make sure that decisions were informed, and I think that has been achieved in this law.
Follow-up coming after Peve's question about the timeline of the application for Minister Lametti, and what the next steps are if you don't get the extension.
Well, we have done everything we feel we possibly can in terms of being diligent to have a piece of legislation before the House of Commons. I had said a number of times to a number of you that I wanted to see a piece of draft legislation in front of the House of Commons by the end of February. We've achieved that. So we've worked pretty diligently to get to this point. We've consulted. We've put together what we think is a thoughtful piece of legislation. We have also, I think, had reasonable success in the past when being diligent at getting extensions. That happened in the Carter case. It happened in other cases as well. So we're in front of the Superior Court tomorrow, in front of the judge, and we hope to succeed. If we don't, we will work with our colleagues in Quebec and make sure that we move ahead in a way that is as least disruptive as possible. But I think we're pretty confident moving forward.
Okay, Lena Dibb, again from La Presse Canadienne, and then Dale Smith, freelance.
Oui, Monsieur Lametti, je voudrais revenir sur la maladie mentale. Étant donné le choix que vous faites dans ce projet de loi-là, est-ce qu'on ne peut pas déjà prévoir les conclusions que vous allez tirer de la révision qui va commencer dans quelques semaines, dans quelques mois à peine, là?
Je crois que non. C'est encore une question complexe. Comme je viens de dire, il faut qu'on soit sensible, mais c'est une question encore ouverte dans le sens que les maladies mentales sont sérieuses, sont des maladies très complexes, et donc il faut regarder comme il le faut pour mieux comprendre les maladies et puis pour encadrer une loi en conséquence. Mais c'est une conversation qu'on va avoir avec les Canadiens et les Canadiennes à travers le Canada. C'est une question que le Québec va avoir aussi. Et donc, ce n'est pas une question close. Ce n'est pas une question terminée.
Et puis pour revenir aux morts raisonnablement prévisibles, vous êtes convaincu que dans la manière dont vous avez écrit votre projet de loi, ce n'est plus attaquable, ce concept-là, étant donné que ce n'est... Pourquoi, en fait, vous croyez que ce ne sera pas attaquable?
Parce qu'on a... ce que la Cour supérieure nous a demandé de faire, c'était d'élargir l'étendue de la loi. Et c'est ce qu'on a fait. Donc, oui, évidemment, la grande majorité des cas vont tomber sous la fin de vie, si on veut. Mais on a ouvert la porte à d'autres cas qui ne sont pas en fin de vie. Et on l'a fait d'une façon équilibrée, d'une façon sensible. Et je crois, je suis confiant que ça va être trouvé constitutionnel.
Okay, Dale Smith, and then we're going to go to Kristen Schmitz from the Lawyers Daily.
Hi. My first question is for Minister Lametti, and I'm wondering if you can walk us through your thinking in certifying the bill for its constitutionality.
Well, we again, the main criterion that we were looking at was that the RFND, the reasonable foreseeability of natural death criterion, closed the door to too many people, and that was found to be unconstitutional on Section 7, Section 15 grounds, so both security of the person and equality rights. We think we have opened access sufficiently to meet the court's concerns with respect to that criterion. So that criterion no longer acts as a barrier. It acts as a channel between the two streams. The vast majority of cases will still be in that first stream, but for those that don't fall into that stream, which is what the court asked us to look at, we're opening another avenue for analysis and evaluation.
And my second question is basically just why would you not start the legislative review now and kind of get it all done in one fell swoop?
To be perfectly honest with you, it's a question of human resources, of our parliamentary colleagues. We would like to get this done, and we don't. So we'd like to get this done. That other review will be longer, will be complex. We want to get this done quickly. The court has asked us to get this done quickly, and people are suffering in the meantime under the current regime. Think about the 10-day rule. Think about the Audrey Parker Amendment, for example, and we want to sincerely reduce the suffering that people are going through, that families are going through. And so let's get this done quickly. That allows us to breathe and move our resources, our human resources, quite literally, to the next step.
Okay, Kristen Schmitz with the Lawyers Daily, and then Peter Mazereau from the Hill Times.
So just following on that, can you walk us through why you think it is constitutional to exclude people with mental illness from MAID?
Well, there is such a degree of complexity there with regards to the varying kinds of mental illness, and while there's increasing understanding of various kinds of mental illness, we still need to know more, and we still need more evaluation and analysis. The number of cases in which the only thing we've excluded is mental illness as the sole criterion, and that's a very, very small number of cases. It's often the case, as Minister Hadju has just said in her opening remarks, it's often the case that mental illness is part of a larger set of medical conditions, and a doctor will still be able to evaluate those other conditions, and perhaps a person will qualify. So we're not eliminating. We're only eliminating a small group for the time being, and we've made a commitment to look at it in the future.
What's the policy reason, Minister, for that?
It's complex. There's no consensus, and so we need more time.
And lastly, what is the standard that you applied, the legal standard, to certify this bill constitutional?
Well, every bill has a charter analysis, and that will be presented in the House of Commons in due course.
Was it balance of probabilities or something much lower than that?
As I said, we'll put that in front of the House of Commons in due course. Thank you.
Great. Okay, so Peter Mazereau with the Hill Times, and then we're going to go to Charlie Pinkerton from iPolitics.
Thanks. Obviously, there are a lot of seemingly very carefully thought out rules and requirements and restrictions in this bill. As you know, we're in a minority parliament, a more independent Senate. Are you open to amendments?
We're certainly not closed to amendments, I think, is probably the better way to put it. I mean, everybody wants their bills to get through without amendment, but I think it's fair to say that we understand that there is committee work that's going to be done. There's going to be work done in the Senate, and we're in a minority situation, and so we will consider all reasonable suggestions. And we'll come to some sort of compromise with our parliamentary partners.
As a follow-up, there has been a lot of talk about this parliamentary review. Parliamentary reviews are often ignored by the government of the day. Is this any different? Should we expect to see more legislation coming a year from now at the end of this process?
I would, if you don't mind, I would answer by saying 300,000 Canadians in a fairly short time frame went online to give their opinions. That's indicative of the degree of interest that Canadians have in the subject area. It's something that touches us all. It's something that we have all experienced the death of a loved one, oftentimes in very trying circumstances. Many, many people have an interest and an opinion on this. Many people have been touched by this. We, as a government, I think, have to listen to that. And so I'm pretty confident that this parliamentary review will be something that is closely followed and in which people will participate to a very high degree.
Okay, great. Charlie Pinkerton from iPolitics, and then Joan Bryden from the Canadian Press.
Yeah, hi. So Minister Lametti, you just mentioned this, that you received almost 300,000 I guess, types of input in your consultations, but this still seems like a pretty moderate proposal. So those consultations were done during a pretty busy time for this government, including on the health file, dealing a lot with what's been going on with coronavirus. Did these issues, including dealing with the coronavirus situation, get in the way at all of a more substantive proposal?
Well, I'll answer that from the health perspective, no. We have, thankfully, a very large department. Health Canada is able to talk and chew gum at the same time, thankfully. I will say the coronavirus is being admirably dealt with through the Canadian public, the Canadian Public Health Agency, and they are the lead on the coronavirus. And Health Canada has a number of arms that help support us in a variety of our other mandate items and ongoing issues that they regularly manage.
Can I just add with respect to that question? We had a pretty tight deadline from the Quebec Superior Court. Came to us in the middle of an election period, and then Christmas holidays and that sort of thing. So we knew we had to work hard and we had to be diligent about it, and I think we were. Our consultations were focused. We knew we had to respond to the Truchon decision. We also said from the get-go that we would look for other points of consensus. So we specifically asked about the Audrey Parker scenario in our online consultation, for example. So we were focused in our consultation, knowing we had the backstop of a larger parliamentary review that was going to take place in 2020.
So will those consultations be used to inform the parliamentary review down the road? Because we were told earlier that those consultations, or at least a summary of them, will be made public. So will that come into the picture in the parliamentary review?
Yes, there certainly any information, any data points or any information that we have will be useful. We asked other questions in that online review that went to advanced requests. More particularly, as well as an open-ended space for other kinds of reflections. So we will definitely use that as well.
Joan Bryden from the Canadian Press, and then Melanie Marquis from La Presse.
I'm just wondering what your thoughts are on the constitutionality of creating sort of a double standard based on how sick people are or how close they are to death. You could foresee a situation in which somebody is approved, they're not near death, but they're approved for an assisted death because they're suffering intolerably. And why should they, for instance, have to forego pain medication for fear that they might not be able to give final consent at the end of the day, whereas if they were close to death, they wouldn't have to give that. I'm trying to figure out how you would argue that should this get challenged.
Right. Well, I mean, there is a provision for doctors having discretion if there's severe cognitive decline, even in the non-end-of-life scenario. We think we have given access to MAID to a wide swath of the population, so I think that helps us on both Section 15 and Section 7 grounds. as I said, we will put out the full constitutional, the charter statement, as is our practice in the House of Commons. But we feel that we've increased access. Criteria, illness is different. People suffer from different kinds of illnesses, different kinds of conditions. And I think the access point is the important point. To think that we can then treat every single aspect or element of illness identically, I think is not the charter standard. And so I think we do, moving forward, have a piece of legislation that will pass muster under the charter.
Would you consider referring this to the Supreme Court so that they can weigh in on this instead of having people who are suffering, having to go through a court process and wait years to find out whether this is, in fact, would stand up?
Well, as I said, we're pretty confident that this will pass muster. And we've enlarged access to MAID to a part of the population that didn't have access before. So we hope that that's sufficient. Well, the answer is never really no, but I think we'll wait and see.
I think, Joan, to Minister Lametti's point, I think many of the concerns that I've heard as a member of Parliament around restricted access, I think, are alleviated by this proposed legislation. For example, there is no limitation in terms of a particular illness. This is a discussion between a physician and a patient. There is, obviously criteria around what makes someone eligible, as we would expect, but there is an open-endedness to this that allows for a much deeper relationship between a practitioner and a patient to determine if this is the right step for them in cases where they do not see an immediate death. And so I think, to Minister Lametti's point, having the two-track system actually broadens it to people that previously were not eligible at all. And for those that were eligible, that are actually facing an imminent death, decreases barriers, as in reduces some of the safeguards that we've heard extensively created additional barriers or, in many cases, additional suffering.
Okay, Melanie Marquis with La Presse, and then we're going to go to Peter Stockland with Prima Communications.
Bonjour, ma question pour M. Lametti. Concernant l'avenue de la mort qui n'est pas raisonnablement prévisible, vous avez dit vous croyez en les chances du 90 jours de résister à un test devant les tribunaux. Comment a été choisi le 90 jours qui peut sembler arbitraire comme mesure, comme façon de le quantifier?
On a voulu avoir une période adéquate pour l'évaluation. Il y a souvent, ce qu'on a entendu lors des consultations, dans le cas, pour vous donner un exemple, le cas d'un accident catastrophique, les personnes souvent au début pensent « Oh, j'aimerais mourir ». Mais avec le temps, avec l'évaluation, avec d'autres informations sur les choix de vie qu'ils pourraient avoir, ils sont en mesure de prendre une décision de vivre ainsi. Et donc, on a choisi une période un peu plus longue parce que ce n'est pas en fin de vie. Donc, quand quelqu'un souffre, c'est toujours... le temps est toujours pressant, mais c'était moins pressant que dans l'autre situation. Et donc, on a établi une période assez suffisante pour évaluer, pour que la personne puisse avoir des informations d'un médecin, d'autres experts, et pour vraiment comprendre ce qui se passe dans sa vie.
La première avenue, celle de la mort qui est raisonnablement prévisible, vous, ma collègue l'a mentionné, vous aviez voté contre le projet de loi.
Oui.
Ce que vous déposez aujourd'hui, c'est pas un peu l'aveu que le gouvernement a erré dans ce dossier-là?
Non, écoutez, j'ai voté comme j'ai voté la dernière fois. Je vais pas retourner en 2016. Mais ce que je peux vous dire, on a toujours prévu, et ce sont des discussions qu'on a eues, je pense à la question de Mme Bryden, c'est un peu les discussions qu'on a eues il y a 4 ans. Mais mais on a toujours dit qu'on allait évoluer avec la société canadienne. On allait évoluer avec les standards qui changeaient, avec une certaine acceptabilité de la pratique. Et c'est ce qu'on a fait. Donc, on a passé une autre étape aujourd'hui, une évolution, si vous voulez. Et moi, je suis très satisfait en tant qu'élu.
So we've only got time for like 2 more people here, so hopefully we can get through these in the next couple of minutes. Our next one will go to Peter Stockland from Prima Communications, and then Menon Cornelier from Le Devoir.
Just two clarifications, one on the consultation, one on the issue of mental illness. Can you, will the anecdotal information as well as the quantitative data be available whenever it is that you release the findings from it?
So we plan on releasing a What We Heard report that will provide an overview of what we heard through the online survey, as well as a snapshot of what we heard through the consultations, and absolutely we'll be pulling out pieces of those consultations to give people a sense of the variety of comments and the depth of the comments.
Walk us through a little bit how that data was presented to you in such a compressed time frame that you had confidence, it actually, particularly the quantitative data, that you were confident what you were being presented with, so you could draw these inferences and rewrite the law in the way that you have. I mean, that must have been a pretty crammed time to absorb all that information. How did that happen? How did you do that?
Well, I think the online data is fairly easy to compress fairly quickly. The departments are able to take that information and then present it back to us, and especially the quantitative piece of it. It's actually the qualitative data that's harder, because they come in a variety of themes and have to be themed accordingly. But nonetheless, we have departments that assist us and make sure that we can get that information quickly. In terms of the consultations, we were all at a number of them. I believe Minister Lametti was at all of them. I think most of Carla and I were at several of them, and I think for me that was also very useful, especially being the Minister of Health, in particular listening to the wisdom of practitioners that had been providing the service in a very thoughtful, compassionate way over the last 4 years, and had a lot to say about what was working, what wasn't working so well. But certainly we heard from people living with disabilities, we heard from a variety of different advocates from a variety of different perspectives, and of course all of that is also condensed for us through the department, but certainly was helpful for us to be there present and hearing those.
Clarify quickly on mental illness. You have said it isn't solely, mental illness solely will not be justification for MAID or eligibility for MAID. But as mentioned, as Minister Lametti mentioned, it's an underlying factor in many illnesses, people that are homeless, et cetera. So am I understanding correctly then that someone who is mentally ill but has another condition that may well be correlated to or correspond to their mental illness, they will be eligible for MAID? Is that correct?
So the exclusion is mental illness only as a presenting factor. So many people live with concurrent illnesses. There are many illnesses that cause mental illness, and many mental illnesses that cause physical illness. And I think the challenge for us was around people with a mental illness that often the symptomology is a desire to die, and making sure that we understood that a little bit more deeply before we put that into the proposed legislation. But obviously each decision is on a case-by-case basis, and practitioners have become very good over the last 4 years working with individuals in often very complex situations and determining if it's the right measure for them. And we anticipate that this legislation will give them even more clarity and more options in terms of working with people that are experiencing irremediable suffering.
Great. And so our last question goes to Menon Cornelier from Le Devoir.
Monsieur Lametti, la question est pour vous. Les gens qui vont avoir l'aide médicale à mourir, genre le 12 juillet, vous espérez que le 11 juillet, votre loi fédérale va être en vigueur. Donc, le 12 juillet, vont pouvoir se prévaloir quand même même si leur demande a été faite avant, ils vont se prévaloir des assouplissements. Est-ce que les gens qui ont besoin de 90 jours d'évaluation avant de pouvoir se prévaloir de l'aide médicale à mourir pourraient, par exemple, faire leur demande maintenant, subir toutes les évaluations que vous prévoyez dans votre loi, de telle manière que quand la loi va rentrer en vigueur en juillet, si vous obtenez votre extension, ils pourront automatiquement y avoir droit?
Je dois regarder Oui.
Beaucoup cette demande d'extension, entre autres au Québec, ils disent au moins laisser aux Québécois la possibilité d'avoir accès tout de suite.
En principe, la nouvelle option, si vous voulez, n'entrera pas en vigueur qu'après la sanction royale. Oui, on a dit dans les cas de fin de vie, ils peuvent bénéficier des assouplissements. Je crois qu'on n'aura pas un tel choix, si j'ai bien compris, avant la sanction royale. Donc, il faut, pour les personnes qui ne sont pas dans la position fin de vie, il faut qu'ils attendent.
Est-ce qu'ils pourraient, par exemple, ils ne peuvent pas commencer les évaluations ou s'ils le font déjà, elles ne seront pas prises en considération à ce moment-là?
Là, je vais laisser la question à nos personnes techniques. Mais en principe, je crois que ça doit être fait après. Mais on n'est pas ici pour faire souffrir les gens. Et comme la ministre Hadju vient de dire, les médecins vont avoir un rôle clé à jouer dans l'évaluation de leur cas. Et ils ont déjà une responsabilité et une discrétion selon la loi. Et espérons qu'ils vont agir d'une façon responsable. C'est ce qu'ils ont fait jusqu'ici.
Mais est-ce que vous auriez pu accepter qu'au Québec, ça rentre en vigueur, puis pas dans le reste du pays?
Le Québec peut régler dans le domaine de la santé. Nous avons les modifications du Code criminel. Le Québec ne peut pas aller contre ce qu'on est en train de faire parce qu'ils ne peuvent pas aller contre le Code criminel. Il peut ajouter d'autres critères pour réduire ce qu'on a fait, mais ils ne peuvent pas donner des droits qui vont contre ce qu'on a fait en droit criminel.
C'est juste parce que votre clause à vous aussi, elle est rendue inconstitutionnelle au Québec si vous n'avez pas de prolongation. Ça faisait pas votre affaire.
Si on n'a pas la prorogation, on aura une situation où la loi pourrait être interprétée différemment au Québec pour une période de temps.
Pourquoi vous ne pouviez pas vivre avec ça?
We're going to wrap it up after this, just to make sure that we're respecting the time of everyone here. But yeah, go ahead and answer.
Bien, on va faire ce qu'il faut faire, mais on va trouver une entente. Si le cas échéant, on va trouver une entente avec le Québec pour réduire les différences. Ça pourrait créer d'autres causes devant les tribunaux pour des gens dans les autres provinces qui voudraient avoir les mêmes droits que les gens au Québec. Donc, ce n'est pas une situation idéale. Et donc, on a fait le tout pour ne pas avoir une telle situation et espérons que ça va aller.
All right, that concludes the press conference for today. Thank you so much for joining us.
Merci.